Hi folks, and welcome back to Contract Law. This is video 4 in the video series for the vitiating factor of misrepresentation and the statutory version of that, which is misleading or deceptive conduct under the Competition and Consumer Act. And in video 1, we did an overview of this topic. In video 2, we had a look at misrepresentation of common law and rescission. In video 3, we started off our journey on the Competition and Consumer Act and the Australian Consumer Law, which is Schedule 2 of that Act. We had a look at the first 3 elements of an action under Section 18 of the ACL, which is a person must not in trade or commerce engage in conduct. And the 4th element is that is misleading or deceptive or likely to mislead or deceive. So we need to cover off that final element and we need to look at remedies in this video. So without further ado, let's jump into where we were up to, which is the requirement that the conduct either mislead or deceive or be likely to mislead or deceive. And the test for that one, rather simply, is whether it would lead someone into error. And that's the Parkdale case, which we'll discuss in just a moment. Note that there is absolutely no requirement of intention here. So an innocently misleading statement may well contravene Section 18, much like you can have innocent misrepresentations at common law. The test is objective. It's simply a question of fact that is determined by the court after looking at all the surrounding circumstances. And there's a few salient aspects that we need to consider when we are trying to determine whether conduct might be misleading or deceptive and therefore contrary to Section 18. The first thing is that you need to think about your audience. And this is what you'll find once you've read a few cases on Section 18. The judges tend to first sit down and think about who exactly the statement was addressed to. So they identify the audience. Sometimes the judges call it identifying the class of persons or the section of the public that would be affected by the misrepresentation. You're trying to determine where this representation was pitched. So obviously, if it was pitched at kids, you're going to be using a very different measuring stick for whether or not something is going to be misleading than if the representation was addressed to an audience of professionals or an informed section of the public. So you need to think about age, knowledge, background, and degree of sophistication there. However, having said that, what the court is invariably careful to do is to bear in mind that this is consumer protection legislation, and therefore, as I've been saying, the net is to be cast as widely as possible. So within any particular section of the public that you're considering, you need to take into account the variability of all members of the class. So you're looking at pretty much anybody that would fall into that class. For example, an advertisement that was marketed for women's cosmetics. You are considering all members that might need to purchase lipstick, mascara, eyeshadow, for example. However, and I love this quote, and it gets used time and again, it never gets old. As Justice Frankie said in the Morningstar case, you look at everybody in that class of persons, but not a moron in a hurry, okay? This is consumer protection legislation, but it's not meant to exculpate or excuse poor decision-making by consumers that just don't take enough time to look after their own basic self-interest. So not the moron in a hurry. The court will look at what the reasonable member of that identified section of the public would think of, okay? How the representation would have been interpreted and received. So that's your audience. The next thing is that the conduct / statement / representation / silence, whatever is being complained about, has to be capable of causing error and it either caused error or would be likely to cause error. So you don't actually have to have any specific instance of error here. It's enough if it's capable of causing error and indeed likely to cause error. In this respect, you need to be careful. Whatever conduct that's being complained of has to actually be capable of misleading, okay? So it's not sufficient that it might make consumers just wonder about the matter or cause some kind of general confusion in people's minds. It has to actually be capable of leading consumers into error, or leading parties into error. So in the Williams Wines case, I love this case, near and dear to my heart. I've been involved in litigation with McDonald's, might I say, successfully. So it was another instance of McDonald's going down. They are litigious protectors of their trademarks, and in this particular case they were alleging that McWilliams Wine's marketing of a wine as the Big Mac might in fact lead consumers into error and somehow make them think that McDonald's was starting to manufacture wine. Yeah, as I said, unsuccessful there. So it has to be actually capable of causing consumer error. In the Campmar and Nike International case, though, that was a successful Section 18 case, or misleading or deceptive conduct case, actually. That was in the old days before the 2010 revisions. But in that case, we had Campmar starting to market a fragrance as Nike Sport Fragrance. And obviously Nike objected to that, and it was held that yes, whilst Nike at that point wasn't marketing sport fragrances, it wasn't such a stretch, given that Nike had engaged in a lot of different franchised materials, and it was marketing actively in other areas and merchandise and so on. It wasn't such a stretch for consumers to actually be misled, thinking that they might be making sport fragrances. So your conduct has to be capable of causing error. Note also that these two cases are great examples of the misleading or deceptive conduct provision being used by other than consumers, being used by big brand manufacturers who are very keen to protect their trade dress and trade reputation trademarks. It's a great example of just the versatility of what we now know as Section 18, and the fact that it's used by a lot more than just the average consumer wanting to object to misleading conduct. It's really used by businesses generally, and usually used in preference to, as I say, the common law cause of action, which is so much more craggy. So that's capable of causing error. The next thing is that the defendant has to be responsible for the misleading or deceptive conduct. And here we have the Parkdale and Puxu case. And in that case, Puxu made some rather expensive and very popular in the late 70s, early 80s furniture called post and rail furniture. Parkdale made some knockoff furniture which it called rawhide. No real shame in that in terms of emulating others for their business success, I guess. Puxu's labels, however, were cut off by some rather naughty retailers so that the knockoff furniture could be sold as the genuine furniture. Now, Puxu certainly were not very happy about that and sued Parkdale. The issue was that Parkdale had actually clearly labelled its products Parkdale. So when they left its factory, there shouldn't have been reason for consumers to be misled. Particularly the court had a look here. It's quite interesting the way that the court analyses the relevant class of persons. Remember I said the first thing that you'd do is you'd work out who exactly the conduct was aimed at. And here the court said, well, if you had consumers that were actually looking for Puxu furniture, this rather expensive post and rail furniture, they'd want to make really sure that they were actually getting what they wanted to get before shelling out that kind of money. and so they would be expected to look for the label. Now, if they didn't find one, then, you know, there should have been questions asked. So Parkdale certainly wasn't responsible for the naughtiness in this particular circumstance. They'd done the right thing, they'd done the labelling, and they were not responsible for any misleading or deception that was going on. So that's Parkdale and Puxu. The last thing is that because the provision actually says that the conduct only has to be likely to mislead or deceive as a minimum, then you obviously don't have to introduce evidence that any particular consumer or particular purchaser or particular person that was the recipient of the conduct was actually misled, okay? The text goes into this a little bit, and I kind of agree. There can be problems with evidence that consumers have been misled, and particularly some consumers seem to be more easily misled than others. For example, the court actually discounted some of the evidence in the Campamara Nike case that we just discussed previously, because one of them said that you know, they thought that the Nike brand was so powerful it would even extend to things like, you know, pet food or toilet cleaner. Clearly, that kind of more extreme extrapolation or interpretation of events is going to be discounted by a court. So they'll engage in this objective assessment as to whether or not conduct was capable of misleading or deceiving, and indeed likely to mislead or deceive. So that's the issue of evidence, and they are the elements of a Section 18 case. The last thing that we need to look at is remedies, and wow, what a grab bag of awesome remedies we have in the Competition and Consumer Act, and particularly in the ACL. Under Section 232, you can get injunctions, but the really interesting, cool stuff is under Section 236, damages, and 237, ancillary orders. Looking first at 236, damages, there's one thing that you first need to kind of mentally flag here, and that is these damages are calculated on the tortious measure, not the contract measure. So like with damages in tort for deceit or in tort for negligence, when we're looking at the common law action for misrepresentation, here under the ACL, if there has been misleading or deceptive conduct, the damages will also be compensatory. That is, they'll look to place the plaintiff back into the position they would have been if the naughty conduct hadn't occurred, okay, if the misleading conduct hadn't occurred. That's what the court's going to be focused on here for damages, not damages in contract, which are sometimes called expectation damages, which aim to place the plaintiff in the position as if the contract had been performed. They're out of the question here. Okay, that's the first thing you need to know. But look at this. You can recover the amount of the loss or damage not just by the person that was principally involved here, but by you can recover from any person involved in the contravention. So then you go and have a look at the definition of involved, and it says a person's involved in a contravention of blah, 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 Section 18, if the person has aided, abetted, counselled, or procured the contravention, or has induced, by threats, promises, otherwise, the contravention, or in any way, directly or indirectly, knowingly concerned in or party to the contravention, or has conspired naughtily with others. So very, very wide net cast there, potentially, for people that might be liable in damages for misleading conduct. That is called accessorial liability, and it's kind of cool. Well, it's cool if you're acting for a plaintiff. The other thing to note is that companies are liable for the misleading conduct of their directors, employees, servants, agents, and that kind of thing, okay? So you'll see in section 139B sub 2, any conduct engaged in on behalf of a body corporate by a director, employee, agent, or so on, or any other person acting within the scope of their authority is taken for the purposes of this part to have been engaged in by the body corporate, okay? So the company will be liable. And that's how you shoot home naughtiness to a company that might have deeper pockets and is therefore worth suing, perhaps more attractive target than the average individual natural person, director, employee, agent, so forth. Then it doesn't mean the director or employee or agent, servant, whoever will get off scot-free. Then you will join them to the action as an accessory, okay, because they were involved. So that's how you determine who is responsible for what in terms of damages. The next thing is section 237/243 ancillary remedies, and these are amazing. Certainly not like anything that you get at common law. And this is really what distinguishes and defines this legislation as being just so appealing to use as your default go-to provision when there's been some naughtiness in terms of misleading conduct. 237 says, a court may, on application of a person who suffered or likely to suffer loss or damage because of conduct of another person that was engaged in a contravention of Section 18, make such order or orders as the court thinks appropriate against the person who engaged in the conduct, or again, accessorial liability, or a person involved in the conduct. Then note 2 says, for orders that the court might make, go ahead and have a look at 243. So then we go ahead and we have a look at 243, and it's an inclusive provision we see immediately without limiting section 237, blah, blah, blah. The kinds of orders include all or any of the following, all or any. So it's like, it's this Christmas present bag of stuff that you might select from. An order declaring the whole or any part of a contract made between the parties, or a collateral arrangement, so not even the main contract, a collateral arrangement between the parties to be void, or if the court thinks fit, to be void ab initio or void at all times on and after such dates specified in the order. So you might actually just have the arrangement being void on and from a certain date. Look at subpara B, an order varying a contract in such ways as the court needs to do so, or declaring the contract or arrangement to have had effect as so varied on and after a particular date. This is really quite incredible stuff. An order refusing to enforce the arrangement. Sub D, an order directing the respondent to refund the money, return property. All sorts of things. I'll leave you to explore the rest of this provision at your leisure. But I think you get my point. There is an incredibly broad scope here for the court to tailor the remedies exactly as required to fit the situation, to fit the problem that's arisen due to the party being misled. So that's why lawyers everywhere know and love the ACL and its attendant remedies for misleading or deceptive conduct. And that, folks, is misleading or deceptive conduct and the statutory remedies available therefore. So, as I always say, if you have any problems or queries, or you'd just like to chat further about the material covered in this video series, please don't hesitate to contact me by email, Teams, Facebook, Moodle. Other than that, I look forward to catching up with you in a tutorial sometime soon. And apart from all of that, thanks for watching. Bye now, guys.